Hi friends from around the world, let's talk about repair clause. That is a clause with significant economic impact in the European Union, and among design lawyers in Europe that is a very important issue. Everybody knows about the repair clause, and so should you who are around the world. So when you talk about your lawyer about a design case and they talk about the repair clause, meaning that for them it is very clear, so you should know what they are talking about, right? That is the issue here. So I want to present you two joint cases from Italy and Germany, which have come to the European Court of Justice. Now, the repair clause is about spare parts, component parts of an overall product. Why is that economically impact? Well, you have long-living cars, for example, or long-living other products, machinery, which are covered by design protection. And then something of the machinery does not go well and has to be repaired, right? So is the original spare parts from the company who owns the design protection, they can sell it at any price if nobody else can touch or can produce these kind of components. So they have a kind of monopoly with regard to that, right? On the other hand, if everybody can make these spare parts, although it is part of a design protection, but can produce it and then sell it to those repair shops, which then incorporate them into the overall design. If that can be done, well, that would be, so to say, a bit painful for the original manufacturer, for the design holder. You understand the big picture? So it is about Article 110 of the Design Regulation. Design regulation, you know this regulation, so directly applicable in the member states. And design regulation here, it is on the screen, and following we have Article 110 of the design regulation. So this is the repair clause. The repair clause is quite at the end of the design regulation, and this is a bit exceptional. Also, the wording of the repair clause is exceptional, as you see on the screen. So this has to do at the moment of the adoption of the design regulation. There was a struggle between lobbying groups. So one group wanted to favor its own industry, Germany probably those of the car manufacturers, and others those of suppliers of component parts or other machinery which are spare parts which have been produced by other countries. And this is in fact reflected by, curiously enough, reflected by the comments. So in the European Court of Justice proceedings, countries, they can present their comments, and Germany presented the comments here with regard to, in favor, so to say, of narrow application of the repair clause, whereas Italy, they lobbied for, or argued for a more wider application of the repair clause. So Article 110, repair clause, that is about. What about the case? So we had two German car manufacturers, which at the fact is one, Porsche and Audi, which both remain under the roof of Volkswagen, right? One seized in Italy and the other in Germany. They seized the same spare parts company, so to say, component parts for motormobile, which is Acacia, which is an Italian company. So Porsche and Audi against Acacia in Italy. We have two proceedings, one in Italy and one in Germany, because they sell also through internet. So Germany was also had the international jurisdiction. And what do they say? Well, the Acacia had on its offer replica wheel rims. So you have wheel rims here, some wheel rims here on the screen. That is not the ones from Acacia. But wheel rims, well, they had the offer in replica wheel rims, which were from Audi and Porsche, and from other companies as well. So we have here only those with Audi and Porsche in contention. Now they said they put on the wheel rims OEM, not OEM, so non-original equipment manufacturer. And they say also in the brochures, etc., that this is not original, that is not the same as the protected ones from Audi and from Porsche. They are replica ones, etc., etc. Now, they seized in Italy and in Germany, and the defense argument of Acacia was, yes, the repair clause. They were covered by the repair clause. Now, Acacia lost in Italy and Germany in the first instances, and then eventually it come up the jurisdiction ladder, and at a certain moment, both courts in Italy and in Germany, both courts, they stayed the proceedings and submitted the questions to the European Court of Justice, and therefore we have they were joined at the moment of the European Court of Justice, and therefore we have one ruling on these two proceedings on the questions which around the same repair clause was being posed. Okay. So that is what is now about the ruling. The ruling says that well, it was the struggle about the scope of protection of the repair clause, and one was a narrow clause. One argued for the narrow clause, so the car manufacturers in this case, they wanted the repair clause only applicable to those parts of the overall design which impact, so to say, on the overall design, which are part of the overall design. Meaning that wheel rims, which are, so to say, customized, as you know, the wheels of the cars are often very much customized in one sense or the other, and you know, to make it more attractive to the consumers, they change to others, and the wheel rims are, so to say, not part of the overall design, and they should be covered also by the repair clause, meaning that the manufacturers of independent things, they were also not privileged by the repair clause, whereas the repair clause said, well, the overall design is one thing, but those which are component parts of that product, they should be covered by the repair clause as well. And the European Court of Justice, they said clearly, well, all component parts of an overall design, whether it is part of that design or not, they are covered by the repair clause, so in favor of Acacia. Wheel rims, which are something which are, so to say, not part of the overall, they are covered by the Acacia, all component parts. Now there are two caveats which have been identified by the Court of Justice. First, only those parts, or only the parts which restore the original appearance of the product, are covered by the repair clause. Only those which restore the original appearance of the goods, of the designed goods. So this is part of the wording of Article 110. So it is a caveat which is, so to say, normal. And the second caveat is that there is a certain responsibility, downstream responsibility for these suppliers, for these manufacturers of component parts of an overall product. And this responsibility says that they have to make clear, as it was the case here, that these are not original component parts, and they should not, they have a certain responsibility to know about the background of their customers, of those who buy the manufacturing parts. If those are, so to say, known as infringers, selling these parts not for repair shops precisely, then that would be a responsibility of the manufacturer not to do so. That would fall back, so to say, on the manufacturer. So this means that there is a certain responsibility that they have to make clear for the downstream customers that they behave according to the jurisdiction, according to what is the limitation of the repair clause. Now, will we have the repair clause as such forever? We don't know. So there was a struggle at the moment of the adoption of the design regulation, and the authorities that didn't want to have this cleared to adopt the design regulation. The design regulation should have been adopted even earlier, and they didn't want to wait to this Gordic knot to be dissolved. So, and still not so to say dissolved. We have seen this case in 2017. But it will be resolved at a certain moment, and with the current ongoing design regulation overhaul, I think we will see it being differently worded. But so far, the repair rule exists, and exists since 12, 15 years. It is an important issue. Is it only applicable to car manufacturers? No, it is applicable to anything. It may be applicable to fashion items. So the handbag of Louis Vuitton, if you have only the handle and you're doing the handle, and the handle is being broken very often, which is not the case, but therefore it is not of so much importance for Louis Vuitton, but it is applicable as well. Or the Armani buttons, or the sunglasses of, Ray-Ban or Luxottica. So it is for everything applicable of what is an overall design, the repair clause.